this has been very controversial. I mean, the argument about judicial activism is an argument we've heard from many people, particularly supporters of the Harper government, dare I say it. And they've ranted and raved about this judicial activism, but that was the decision of Parliament. What people have to be reminded of occasionally was that the judges did not request the increased authority that they inherited with an entrenched Charter of Rights. This was the decision of the elected politicians to thrust on them this added authority. You never, I don't think there's any indication of judges ever kind of lobbying for it. It was a decision that was made by elected politicians. But the subject of judicial activism has been a controversial subject. I mean, certainly when I sat and presided over the same-sex marriage case, I mean, I got a lot of mail about the improper role that was being played by judges, sort of substituting their opinions for the unelected judges, substituting their opinions for elected parliamentarians. I mean, that subject comes up from time to time, and certainly much more so a few years ago than now. Now, fortunately, I mean, Canadian, I mean, seem to have a high level of respect for the Charter of Rights, for an entrenched Charter of Rights. I mean, even the majority of Canadians who probably have very little idea what is in the Charter of Rights, certainly public opinion polls over the years have indicated a very high level of support. And I mean, for example, I remember the former Premier of Alberta, Ralph Klein, my old friend Ralph Klein. I mean, and this goes back 10 years or more, but when he was Premier. But the Supreme Court of Canada came down with a decision in which basically the Supreme Court, you may recall, amended in the Vriend case, I think it was, they amended the Alberta Human Rights Code to say that, to add the words that the prohibition of discrimination on the basis of sexual orientation was illegal. I mean, they read that into the section on the basis of sex, etc., the prohibition. And Ralph Klein, when the Premier, was furious, as were a lot of our friends in Alberta. And he announced right away he was going to use the notwithstanding clause and change the decision. Of course, it would have to be renewed every 5 years. But even in Alberta, which many people seem to believe that it's a little bit to the right of Ontario, for example, with respect to some of these issues, Ralph Klein quickly learned that the level of support for an entrenched Charter of Rights in Alberta was very high, and he backed off entirely his threat to use the notwithstanding clause. So that, I think, is an example. But when all is said and done, I think it's important that the courts continue to realize, which I think the courts did, and when I was on the court, that the role of the courts can only be vital if they retain the respect of the Canadian public. And that is exactly the same with the Charter. The Charter can only remain a meaningful document if it maintains the support, strong support of the Canadian public. So judges certainly recognize, or I hope most of them, if not all, that they don't operate in a vacuum, that as they go about their daily responsibilities, they know that the maintenance of the respect of the public is crucial to their role. So you do have these balancing influences, which I think are very important.